Is the judgment from the Western District Court of Louisiana on July 4th a true victory against the censorship apparatus, or does it fall short? On Journalists for Sale, my colleague Max Jones and I talked to Electronic Frontier Foundation Civil Liberties Director David Greene about his article titled Preliminary Injunction Limiting Government Communications with Platforms Tackles Illegal Jawboning, but fails to provide guidance on what's unconstitutional. Davis says the ruling is indeed notable, given that the government is finally held accountable for their jawboning of social media platforms. But the judgment itself falls short in identifying what is and isn't constitutional, and the ruling includes exceptions that are routinely exercised and exploited by the government already. So we dive into all this on this episode, and don't forget to like, comment, and subscribe to help us fight the algorithm, and we hope you enjoy. Thanks. All right, David, thanks so much for joining us on Journalists for Sale.
Yeah, happy to be here.
So we're going to be talking about your article that everybody should read on the Electronic Frontier Foundation. It's called Preliminary Injunction Limiting Government Communications with Platforms Tackles Illegal Jawboning, but fails to provide guidance on what's unconstitutional. And you say that although the case is notable for holding the government accountable for unconstitutional jawboning of social media platforms, it falls short by not distinguishing between unconstitutional and constitutional interactions. If you had perhaps the ability to write this judgment or modify it, how would you have made that clearer?
Yeah, well, I think I would have worked through the individual examples and really tried to separate those that seemed to cross the line into unconstitutional coercion and intimidation from those that weren't. That would have been really useful. I think it would have given us the confidence that the court had really closely considered the circumstances and all the facts, and also would really give us guidance for moving forward to know, to be able to distinguish between appropriate and inappropriate contact by the government. But the court didn't really do that. I mean, it did go through the evidence, but it found everything to be violations, even things that didn't seem to be, even things that didn't that seemed to be fairly innocuous or even maybe good policy and a good move by the government. And because we didn't get even a single interaction that was said to be appropriate, it really doesn't give us much to go off of.
What are some of the examples of speech that you think was labeled improper in the court order that you think shouldn't have been, that you just referred to?
Yeah, so I should say that I have not gone through and read the entire evidentiary record. So I haven't done that, and so I don't, I can't really fully assess any of the judgments. I'm just going on how they were related in the opinion itself, in the ruling, where the judge was trying to convince us all of his findings. And I could point to a few things. One, I think there's a lot about the CDC, the Centers for Disease Control, and I think the Census Bureau sort of gets lumped in there too, even though it's very unclear what the Census Bureau did. And those interactions seem to be the CDC responding mostly to requests from the platforms who wanted to know, who wanted to eliminate bad public health information from their sites, and were reaching out to the CDC for their, what they should be their authoritative, what the platforms should be their authoritative guidance. So you may argue whether the platform should have looked to the CDC for authoritative guidance, but I don't think there's anything in the law that prevents the CDC from responding to the platforms in that situation. And even when there was affirmative outreach, it was in what was relayed in the ruling seemed to be the type of notification and contact that was just saying, this is what our public health guidance is, this is what the government's guidance is, and not you must take down everything else. So I think that's one example. I think the other thing that is that there's actually the quite prominent in the ruling is the role that some of the independent um, independent misinformation think tanks or entities that they played, the ones associated with the Stanford Internet Observatory, for example, and the University of Washington, and the researchers there do a lot of really great research on misinformation. And what seemed to have been a very, purposeful effort to actually remove the government, from a role, to say that we as a body will consider what the government says, but we are ultimately not going to, the government's actually not going to communicate with the platforms, seemed to, by this court, to be looked at as some type of subterfuge for the government to participate. And I thought that the connections the court laid out between the researchers and the government, in terms of someone sits on their expert panel, someone is a member of their advisory board, things which are actually very routine, and don't usually reveal a lot of active coordination, that those did not seem to be strong enough, strong enough planks to really, build a connection that looked like the government coercing. And I do say all this from the perspective that I think we need to be extremely careful about government interaction with platforms. I'm very much inclined to have a low bar to inappropriate conduct for the government. And I think that that we need to be really careful and to hold government accountable when it does cross the line. But I also think it's important to recognize that there are situations where it's appropriate. It's both legal and probably good policy for the government to communicate with platforms like they communicate with others. And so that's why I think we need to really have some distinctions between what's proper and what's not.
So you're basically distinguishing between, so it's different that so it seems like what you're saying is that the court order kind of makes this claim that the social media companies reaching out to the CDC for guidelines on how to enforce their censorship policy on things like COVID misinformation is not unconstitutional. If they're seeking the help of government, then the government has a right to reply. But where it gets murkier is if the CDC was contacting the social media companies and saying, "Hey, according to our guidelines on this, we don't think this and this and this information should be up." Is that correct?
Yeah, I mean, and even the court makes a distinction between contacting, like it's okay to contact and notify, but it's not okay to urge and encourage and coerce and intimidate. So so notifying and contacting is always okay. What's improper is is coercion, and that could be direct coercion or even subtle coercion, and in intimidation. And when the courts look at this, they say there's even some degree of encouragement that is improper, and so not all encouragement is proper, but sort of some at some end of the spectrum is improper. So what you would look for any entity crossing the line is someone really trying to either directly or subtly threaten some type of penalty against or have the power of the government come down against somebody if they don't comply.
So kind of going along with that, I mean, I've seen in certain examples, like in the Twitter files, for instance, they show that maybe perhaps they don't explicitly threaten or anything, but they allude in some sort of bureaucratic speak or office jargon that they would like this to happen or something. So I feel like it gets kind of, the waters get a little muddy there as well. Do you think that to specify, to prevent this kind of action, there would need to be specific language, perhaps, or like how I'm trying to understand how maybe to tackle that kind of like you're saying, maybe not direct coercion or intimidation, but some sort of hybrid of that.
Yeah, I think where this legal question gets really, really fuzzy is in encouragement, because the courts have said that some encouragement is okay, but other encouragement is not. And the way courts talk about it is encouragement such that they are such that the result is actually the government's result and not the independent decision of the platform. And again, that's not really that helpful in terms of a distinction, which is why it would have been really useful to actually take some of these examples as a way of and looking at what was encouragement and what was not. I do think I agree. It's a hard distinction to make in the abstract of of a set of facts, and that's why it would have been useful for the court to really engage with that in a meaningful way. So so I do think that so one of the things we tend to look for was, were there levers in place? Was it encouragement with some type of lever in place, whether a penalty or some type of benefit? That's one thing you might do. And also, we also start thinking about, well, what is actually what power does government have in this situation, right? So is this an agency that actually has the ability to impose a penalty, or whether so for example, like interactions with law enforcement may be inherently intimidating, and because everyone knows that law enforcement has at its ready, it's available to exercise penalties on people. It can arrest people, for example. And so with law enforcement, we tend to be on the lookout for even very, very subtle coercion, because they have the inherent ability to impose a penalty. With something like the CDC or some other agency, it doesn't really have enforcement ability, because it's an agency that's about devising policy but not necessarily enforcing policy. Then you really are trying to look for something else.
And so going back to the idea, like the thing you said about the virality project and the Stanford election, what is it, election integrity project, I believe
Yeah,
it's
the
called.
EIP. Yeah.
Yeah. And I understand that they probably do good work sometimes. I haven't looked into it myself personally, but uh, when these think tanks and NGOs and stuff like that have government backing, whether it be through funds or people that are previously from government on their boards, or people that were on their boards going into government, and etc. When they are, like, if government is kind of using them indirectly as a proxy to request censorship uh, um, that acts on behalf of what the government's interests are. Like, for example, the Virality Project, I think Taibbi revealed in the Twitter files, showed that they were basically requesting the censorship of true information that encouraged vaccine hesitancy. Um, what is the like legality of this, and the constitutionality of this? Like, if these government if these independent quote unquote think tanks are receiving government funding, or they're backed by the government in some indirect way, but does that not matter legally when they're
Well,
making these censorship requests?
yeah, no, it's a good question. I mean, it matters. It's just not to. I mean, it's just not determined. The like government funding itself just isn't determinative. What you're really looking for, whereas, is that this private entity is really just doing is really trying to do the bidding of the government and not its own independent work. And the mere fact of government funding does not prove that. It's one of the things that certainly might be relevant. We're typically going to look for a lot more active coordination between the government and the private entity, or look to see whether the private entity is merely just a shell, like just something that's there just to create some type of artificial independence. I'm not claiming to be an expert on how these entities are organized. I'm just saying I thought that the facts that were laid out in the ruling to justify the judgment didn't, to me, seem to prove that lack of independence by these entities. People can completely disagree with the judgment the Virality Project, all these other misinformation entities were making. That's why, but it only creates a constitutional problem when they are acting as the government themselves, instead of being independent entities.
is this where that low or high bar comes into play that you talk about in your article about, in order for private entities to be considered state actors, this idea that they have to replace the intermediary's editorial policy with its own. It seeds its editorial into implementation. All these things. Is that what you're referring to?
Yeah, I mean that was really answering the question of when the platforms themselves are state actors, because there have been a few lawsuits against the platforms themselves, trying to establish that platforms violate First Amendment rights as because they're private entities. They can't violate First Amendment rights unless they are found to be state actors. Basically, that their action is government action, and so those factors you just talked about are what we propose and advocate for using to determine whether the platforms. And we think that high bar is necessary because otherwise the platforms themselves have strong First Amendment rights to edit and curate their sites and to make editorial decisions about what content they want up and don't want. So that's what that test specifically refers to. That I think it would probably be a similar analysis when you're looking at then sort of the next level of actor as well. But I think certainly we want the platforms to be able to receive advice and from a variety of sources, right? We certainly want the platforms to be able to to ask people they consider to be experts of all sorts for their opinions. I don't know that it would be a great result if the platforms were prevented from interacting with people just because they received government money. If that was the only factor. I should also say, like, as someone who's worked in the nonprofit sector for 30 years, I think I'm also a fan of not of nonprofit entities refusing to take government money. But especially when you have research organizations, I mean, the government funding is a huge, a very productive source of research funding. So I understand it's different for someone who's worked in sort of nonprofit advocacy, where we often sue the government to say we're not going to take government money, as others who are actually doing work that is very consistent with research priorities around the world. That's a much different situation.
So whether it was whether the advice given to these or given by these think tanks and nonprofits was corrupted or influenced by big pharma money or government money or maybe not money directly, but some other kind of, because I think that's what a lot of people that are celebrating this decision are worried about. Like, they point to the fact that, look, this virality project was requesting censorship of true information that promoted vaccine hesitancy, as though Twitter should listen to that. Like, so what if it promotes vaccine hesitancy if it's true, and if your goal is to censor quote unquote misinformation? But I think what you're trying to say is that, like, the precedent of kind of, because I think that the order specifically barred them from talking to these specific think tanks, if I remember correctly. Yeah, and you're saying that that's not a great precedent to set for, like, companies consulting nonprofits, whether they don't have government funding, right?
I think so. I think if we would have a rule that says that anyone who receives government funding can't talk to platforms and offer them expertise and advice, then platforms would lose a really valuable source of expertise and advice. Again, we might not agree with all that, we might not like all this advice, and we might hope they're getting advice from other people as well. But I think just to exclude everyone, only if the only factor is that they receive government funding, I think would exclude a huge amount of available expertise. And I say that understanding that what we all have to understand is that not even the hugest platforms like YouTube and Facebook have the internal resources necessary to make good content moderation decisions. They're all need to, or we should want them all to look to outside expertise. Like that is the best way for all the rest of us who are users, is when we're not relying on these big company, not whatever size company, but even the ones who can afford to really staff up and have really robust trust and safety teams. We don't want to be relying on them to make these decisions purely internally. We want them seeking out expertise, and we want them seeking out really high quality expertise, and we want them seek out expertise from a number of sources. And if they are forbidden from doing that, or even discouraged from doing that because someone receives government money, I don't think that would be a good result for the rest of us.
Two quick things. I'm not 100% sure if I don't know if in the court order does it specify, because I know that it bars them from talking to those specific think tanks, but does it actually link the reasoning to that, the fact that they have government funding, or do they just kind of name them arbitrarily? And also, isn't another way for them to enforce like, I'm sure I agree with you that they should be able to consult outside groups, but like a better precedent, I think, than like constantly consulting people on what is and is not misinformation, especially during something like the coronavirus, which was a novel pandemic and true information was censored repeatedly, often when it was in conflict to the narratives that the government was disseminating. Um, isn't it like a better precedent that is the speech constitutionally protected? So even if it is misinformation, leave it up if it's not illegal. What do you think about those two
Well,
things?
that would require some type of rule that the platforms themselves had to had a legal responsibility to publish all to publish all truthful speech. I think that's constitutionally problematic to do that. I think platforms have First Amendment rights themselves, the way other speech intermediaries do, and the way other publishers do, to decide what they want to publish and what they don't want to publish. I might really disagree with their judgments and might wish they published and made different decisions, but they certainly have the right. I believe they have the right to do so. And I think, again, we as users who generally benefit from being able to choose among platforms that adopt their own editorial policies and their own curatorial policies. So if a platform had said, look, we as a platform 100% want to further, we're big vaccine fans, and we agree with the government's vaccine efforts, and we think that vaccine hesitancy is a problem, so we want to remove information about vaccine hesitancy from our sites. We think that it is not high quality information. They have a right to do that. The question in these cases is, what is government's role in that situation? So if someone makes an editorial choice and says, I'm going to be a pro-vaccine social media site, they have a right to make that choice. If they go to the government and say, we're a pro-vaccine, we want to make sure we have the best information from the CDC, should the CDC or whatever, the national the infectious disease agency, whoever they go to, who's administering the programs, we want to make sure we have the correct result, and we're asking you to give us some authoritative information so we can make those judgments. Is that improper? I don't think so. What we want to be careful about is the situation where someone doesn't want to play that role. They haven't made that curatorial decision, and the government is going to them and saying, this should be your editorial policy. This should be your editorial policy. You should do this, and if you don't, and then there's either real or subtle threats behind that. I think we saw that more with the examples of Robert Flaherty, which seemed to be calling out the again. I haven't read the whole record, but just the parts that were included in the ruling seemed to be more about really calling out for specific decisions he disagreed with, asking them why they were, calling them out, asking for information how they made those decisions. Seems to be actually be saying okay, now you've made the decision, I don't like it, and I want you to change it. Is much different than someone saying, we've adopted this policy of wanting to have, our editorial position is to promote vaccination, and then trying to move on with that policy.
So I wanted to bring up this one part that you, I believe, found problematic that the injunction doesn't apply contacting or notifying platforms about illegal campaign contributions, cyber attacks against election infrastructure, or foreign attempts to influence elections, threats that threaten the public safety or security of the U.S., or postings intending to mislead voters about voting requirements and procedures. Correct me if I'm wrong, but you found that redundant, right, with what's already protected by the First Amendment?
Yeah, so as I said earlier, the First Amendment, we make this distinction between notifying and contacting, which is proper, and and coercing and intimidating, and again that subset of encouragement, that is not proper. So notifying and contacting people on everything, there's no problem even without this order. There's no problem. I think what the court might have been doing was just trying to clarify that, just to be clear that we're not preventing the government from doing any of these things, but all types of merely communicating and notifying people, platforms is okay. I thought what was in, so that's what I'm saying. It wasn't necessary to be in the injunction. It's basically saying things that are protected you can continue to do. And again, it's not necessarily an awful thing that it's in there, because because again, I think it was the court trying to clarify. I think what's more interesting is that a lot of the examples the court gives seem to actually cover a lot of the communications which the court identified. So I think about the concern for that they can communicate, notify, and contact them about voting, certain types of voting misinformation. That would actually seem to cover at least some of the communications that the court then also sets out as the basis for the injunction. So I found it a bit confusing in that respect. And I also don't think that I think when I was writing that, one of the things I was addressing was a question about whether or not those exceptions really help to narrow the injunction, because this injunction is very, very broad. It applies to thousands of people. It covers a lot of communications, and I don't think that this is really necessarily does anything to narrow the injunction, as because again, it's all things that were protected anyway.
Right. And it's just interesting that they mention it specifically, because as soon as I read that, I thought about Russiagate and how, perhaps there isn't something like that, but the government or figures within the government can sort of just make up a problem, and, kind of then start to influence and, like you said, contact. And although this is allowed, I'm just curious as to how it works with things that perhaps just aren't true. I mean, lying is not barred from the First Amendment, but I don't know. It's just interesting in regards to that case and how widespread it was and how much censorship that led to, and everything.
Yeah.
Sorry,
Go
if I
ahead,
could
Matt.
just add something to what Diego said. Yeah, it just seems that like because when I read the national security threats and problems of cyber attacks on election infrastructure and things like that are protected, or are exceptions to this order. The first thing that I thought was, well, it seems that they already invoke a national security reason for almost all of the times that they contact these social media companies, pressuring them to censor, whether or not there is a national security threat. So yeah, just what do we make of that?
Yeah, so there's two ways of looking at these exceptions, or I should say, these exceptions have two elements to them. First is the acts that they permit, and the second thing is the subject matters. So the acts that they permit are notifying and contacting, and those are different than the acts that are prohibited, which are essentially, let me get them in front of me so that I urging, encouraging, pressuring, or inducing. So you could look at them and say the exceptions are different because they're making a distinction between urging, encouraging, inducing, and notifying and contacting, right? That you can do sort of non-coercive communications. So that's one way of looking at them. And then the second thing is that, but they also just they do specify certain subject matters of speech, which seems weird because they wouldn't have to. Because again, the First Amendment protects really them to notify and contact them about anything, even if as long as they're not coercing, inducing, encouraging. And so the subject matters maybe reveal something about things the court thought it was important for them to continue to have communications about. And that's why when you see something really broad, like the very first one is, or not the very first one, the fourth one, informing social media companies of threats that threaten the public safety or security of the U.S. Well, that's a lot of I think that's a lot of stuff. What is the public safety of the U.S.? Does that include a public health crisis? Does that include a vaccination program? Now, you may disagree. People who disagree about vaccines may disagree with public safety, but for the government that's trying to interpret what it cannot do under the order, I think the government believes that a vaccine campaign is a public safety campaign. Anyway, so that's what I'm saying. We're not. It's in some ways we can look and say maybe the court was just distinguishing between the type of sort of the intensity of the communications. Like it's okay to notify and contact. It's not okay to urge, induce. But again, we do have these various subject matters set out. And the thing that I thought was most noticeable is that we completely include law enforcement among the things that are permitted, and I think law enforcement is actually the most inherently coercive because again, it's so easy for law enforcement to impose a penalty, impose the coercive penalty on whoever is being contacted.
Yeah, about that, I'd like you to, in a second, go into the example of the UK's, I forget the name of the I think it was something EDA or something like that.
The drill music.
The drill music example. I want if you could get into that in a second, but I wanted to ask you first. You say this is relating to what you just said in the article. You say, "quote The court's injunction likewise applies to whole government agencies and perhaps thousands of federal employees. It is not limited to specific examples of interactions discussed, and it prohibits not only coercion and forceful encouragement, but all urging and encouraging." And you just kind of gave an example of like notifying as opposed to coercing. And I wanted to ask. Does this like notifying like notifying of a national security threat, for example, does it take into account like in the court order, or can you take this into account legally when, like, for example, a lot of times these government institutions that, like the DNC, for example, or even in the intelligence apparatus that is often in communication with political parties, or like the DNC or the RNC, that depending on who's in power at the moment, a lot of times these institutions that are kindly requesting censorship actually possess the power to obstruct or threaten the monopoly power of these companies. So like in that context, the polite, non-coercive language used to make the request suddenly becomes more nuanced. So how does the law account for this context if it can? And do you think that it should account for it if it doesn't?
Yeah, so this is something that courts consider in trying to see whether something was subtly coercive. Like, and I talked before about the idea that maybe there's some type of a threat of penalty if you don't comply. And one of the things that came up in one of the arguments that was made in this case, and I actually think it's a decent argument, is that the power that DOJ had to do some antitrust enforcement against these companies was that was a subtle threat. I think that completely is potentially a threat. I don't really have an issue with that part of the court's order. I don't know how much that can extend to the executive branch completely as a whole. I mean, for example, the Surgeon General's office isn't typically involved in antitrust enforcement, and nor is the CDC. But I do think it's important to consider that it is something that the executive branch through the Department of Justice can pursue on its own. I do think that's realistically only a threat with respect to sort of the very largest companies. So I think it's completely a threat with respect to like Facebook and Google through YouTube and things like that. I don't, as far as I understand, it's not something that would be aimed at some that really things that were smaller than those companies. But again, that's not to downplay its important. I just think that I do think, in response to your question, that to me the threat of antitrust enforcement is something that could take a communication that might be proper in another context and make it coercive.
Just to reiterate what Max was saying before, if you could get into the whole thing in the UK with the drill music, um, that would be awesome.
Yeah, and so this is referring to a situation that was disclosed. This is specifically with respect to, I believe it was Facebook. It was one of the Meta products, where and one of the things I actually find very very concerning in terms of sort of government involvement in contact moderation is that it's very very routine around the world for law enforcement agencies to have like a sort of special backdoor into the content moderation process. Law enforcement is not the only one who does that, right? I mean, there's governments have this, some sort of experts, authorities have this, some type of civil society, nonprofit organizations have that as well. But law enforcement around the world certainly does. And one example of this, and this is very, very common in the US also, but one example that became quite prominent because it was taken up by Meta's oversight board was that the law enforcement in the Metropolitan Police in London were repeatedly flagging content that contained drill music as illegal content, as being either illegal gang-related content or inherently threatening or hateful content. And we're continuously flagging that for when it appeared on Facebook, and it was routinely coming down. And some of the posters appealed this. The appeal was rejected, and this is a case that the oversight board then took up. And the reason we know so much about it was because the oversight board took it up, and the oversight board actually was able to get a lot of information, both from Meta itself as well as from the Metropolitan Police through public information laws, to find out just how completely extensive this was. And the oversight board ended up overturning those decisions and recommending to Meta that it adjust its policy to specifically address that. But I think, to me, it's a good example of why I think law enforcement involvement. I mean, what people say is, well, law enforcement should be able to tell these platforms where they see something illegal on the sites. It's just not that easy, right? I mean, it's what law enforcement thinks is illegal is not necessarily illegal. Like, law enforcement doesn't, although law enforcement, we want them to make some decisions, right? They actually don't make the ultimate decision about whether speech is legal or not. That is made by a court after a full and fair adjudication, and these are often very difficult situations. But what we see is law enforcement taking down taking down a lot of speech. We see this with over police communities quite a bit. We see this with sexual material as well, and so I find that to be, again, one among the most problematic examples of government interference in these processes.
I wanted to go back and ask you again about the high bar for private entities being considered state actors. It's a bit unrelated, but that made me think about the reporting. I don't know if you're familiar with Alan McLeod's reporting at Minpress News, but he's reported numerous times that there's a sort of phenomenon where former CIA, FBI, even Israeli intelligence employees now hold high positions at Meta, Twitter, Google, etc., in sort of this content moderation, public safety, whatever their names are for it. Um, and although, I don't think we can necessarily prove that their intention is to hold water for their former employers, isn't that proximity? I'm just curious on your opinion on this. Isn't that proximity between these government agencies and big tech companies concerning? Um, and at what point does hiring these kind of former agents impede this high bar? I know it's kind of like a three-pronged thing, but that just made me think about it.
I think we can be really concerned about who are hired to sort of run these divisions. The tendency, even for like I think the platforms everyone loves, is to when they want someone to be able to address national security issues, they hire someone with national security expertise, and they tend to hire those people from the government. The same thing if they want someone who has, they need somebody who has some expert who's going to sort of head up a division on, on foreign relations and relations with other governments. They tend to hire people either from those other governments or someone from the U.S. government who has that type of diplomatic experience. So I think we can be really concerned when people are hired, especially if we think people who have not shown a proper respect for human rights when they did when they were in their government jobs. I think we'd be greatly concerned. That being said, it doesn't raise a legal concern, unless we think the person is actually sort of actively a proxy for the government. We have to prove that.
Right.
As well. Unfortunately, it's so routine to hire ex-government people into types of positions that I don't think we can automatically assume that just because someone's been hired, someone was a former CIA or whatever, that they are continuing to do the bidding of the government. I think we can sort of look to say they were hired because we could question why they were hired and what was the expertise the companies were seeking. We can really ask those questions. But in terms of sort of the legal concern that the government is actually the government operating, really would need to see that some type of remaining active connection between the government and the former employer and the current employer.
And just going back a little bit to something you said about how if a social media company openly wants to say that they're very pro-vaccine and they don't want to allow information on their site that promotes vaccine hesitancy or something else, for example, isn't that in contradiction with the role that, if I'm not mistaken, Section 230 of the Communications Decency Act assigned to these platforms as neutral providers that aren't supposed to editorialize?
It's completely consistent with Section 230. Section 230 has no requirement at all whatsoever in any place at all that anyone be neutral. The purpose of Section 230 was to take neutrality out of the question completely, to take the penalties that were associated with non-neutrality out of the question. And so Section 230 does not require neutrality. It does not penalize non-neutrality. It makes neutrality or the lack of neutrality completely irrelevant. So what they did, adopting editorial positions, adopting curatorial policies, is completely consistent with Section 230 and also completely consistent with the First Amendment.
Okay, so actually, so Section 230 in reality, because I always thought that they were expected to be neutral providers, and that if they started editorializing, that they could lose that protection.
Yeah,
okay, so it's actually
it's a myth. Section 230 doesn't require that. It's never required that. You're not the only person who thinks that, who has been told that, or is learned, but it doesn't require that. In fact, it actually requires the exact opposite. So the purpose of Section 230, without it, there were certain situations in which there was a disincentive or there were incentives to be neutral. And what Section 230 was really to remove the disincentives against being non-neutral. And those disincentives typically would prevent people from doing things, the type of moderation that regulators and other people liked, in terms of, if they wanted to have a site that was more family friendly, they were able to do that. If they wanted to have a site that was just, specific to a certain category, they wanted to have a site that was about running. They could have that, right? And so Section 230 was to make the question of neutrality irrelevant, and it's always functioned that way and functions that way to this day. So it's just a misconception that Section 230 requires neutrality in any way.
Okay, that's good to know, because I was misinformed on that for a long time.
You're not the only one.
Yeah. So in the article, you also say, quote, government should be able to criticize the content moderation practices and policies of social media companies without violating the First Amendment, as long as they are not expressly or implicitly threatening them with a penalty for failing to do the government's bidding. So I wanted to ask you, what happens when the government's threats are very implicit or non-direct, such as when Biden claimed that Facebook was killing people for, quote, he literally said that they were killing people for allowing vaccine disinformation on their platform. This is obviously threatening to a platform, to the company, because I think it implies to stockholders, Facebook is a risky investment. So as long as its policy is killing people, it's indirectly suggesting, you better change your policy or your stock price is going to drop, or you're going to be met with some other kind of repercussions. So are these the kind of implicit threats that you're referring to as unconstitutional?
Well, I haven't really the stock price one. I don't think so. I mean, what we're really looking for is something the government has the direct ability to do. So, like a penalty, the government has the ability to impose. So we certainly, I don't think we want to tell the government it can't criticize Facebook, like, and say, you're doing a bad job. I think what we don't want to be able to say, you're doing a bad job, and if you don't get better, we're going to do this. And so the government doesn't control the Facebook's stock price. I mean, obviously there are situations in which the government might have a role in closing a market, but I don't think that's what we're talking about. So I don't think we're not looking at something that's a threat that's as attenuated. What you're really looking for something is some exercise of the power the government has. And again, I think when we're talking about the office of the president, there's a lot that can happen, right? There's a lot. I think the office of the president is something like law enforcement, which is inherently coercive, and so I do think that the government has to be really careful. But I don't think we want to say that every piece of criticism is improper. I don't know that we want to completely take the government's bully pulpit away to be able to call out these companies. I don't think that's a good result for the rest of us.
And so just to wrap up, I was really curious because I think both Max and I agreed that when this news first broke, a lot of kind of like the lefty or whatever you want to call it media space, the independent media space was championing this decision a lot, and it wasn't until we read your article that it kind of sobered us up and made us realize, okay, it's not as grand or whatever as it may seem. Do you think that this kind of celebration is because these people are vindicated in a way where they used to say like this exists and they were called conspiracy theorists and everything, but now it's in the legal record that it's being acknowledged for the first time, right?
So just based on the language, that I don't know why people react the way they do. I'm not a sociologist. So I don't know how people react, but I think the one of the things I thought was very notable about the ruling is that it gave a judicial imprimatur to the idea of conservative censorship. And you'll see this throughout the ruling, that there's a narrative that was presented to the court by the parties, that these were not individual instances of government takedown requests, that this was part of a broader campaign to silence conservative voices, and under the sort of label of conservative censorship. And there were many references to that throughout the opinion. There's that line in the opinion, which many people are noting, where it said this is the most massive, censorship campaign in U.S. history, which I don't agree with. But I think for people who, and for those who study content moderation, scholars who study content moderation around the world, I think they have a different take on whether there's conservative censorship. I think statistically, pro-Palestinian content is the most commonly taken down content, and that doesn't really seem to fit in. Anyway, I mean, there's lots of whether you buy into that or not. What this opinion did was, I think, a vindication of that. If you are someone who believes that there is disproportionately conservative censorship, and you saw this in the opinion, you felt there was some vindication in that. I think for those who completely reject the idea of conservative censorship, whatever that means to them, they saw this for opinions being completely ridiculous and crazy, right? And so I think that, and I think that was the court's framing. I think one of the reasons the court didn't really pick through as carefully and as finely as I think they should have the individual incidents was because they saw this as they agreed that this was a sort of coordinated effort throughout the entire executive branch to suppress conservative speech, and so maybe that explains sort of what you saw, the very extreme reactions to the ruling, because we haven't really seen in court decisions that type of sort of judicial imprimatur on the idea of conservative of the sort of conservative censorship in the way that phrase is used.
And also, do you find an issue with the fact that this is being politicized in a way where freedom of speech and all these principles are being now associated with the right, with conservatives, because of the judge being a Trump appointee and the attorney generals being Republican?
Well, I think it's I completely get what you're saying. I think this, because of the references I was talking about in the ruling to conservative censorship. I think this was written as a political opinion, so I don't fault anybody but the court for the ruling being politicized. I think the larger question of is freedom of speech become a principle on the right instead of one that is sort of across the spectrum, or one was on the left, I think is a really interesting phenomenon. I've been doing free speech work for 30 plus years, and I've seen this sort of bounce back and forth continuously throughout. And I think the present moment is a really odd one for that. For this, I see speech as being attacked, freedom of speech being attacked across the spectrum, and no, which has really always been the case, and no sort of political ideology really being a true free speech champion. I mean, everyone talks about and everything.
On this idea that freedom of speech historically has known no ideology, maybe other than like true civil libertarians, but regarding like right wing or left wing, that it kind of seems to fluctuate and change as to who's really championing it rhetorically or substantively, based on the interest that it's serving at the current moment. But I guess the question I wanted to ask you is like, well, there is absolutely issues of freedom of speech that coming from the right, like I'm not going to comment on this confidently because I haven't looked into it too much, but I know that there's a lot of controversy about Ron DeSantis, I think, in preventing people from learning about critical race theory and such things like that. And but again, I'm not going to comment on that confidently. But I think that like a lot of our readers and myself and many people that I know, I think, have this idea that that at least rhetorically right now, the most egregious and blatantly censorious kind of calls or attacks on the First Amendment and freedom of speech are usually coming from the liberal left. Like you have people like AOC calling for Tucker Carlson to be taken off the air and banned from TV, and you have like almost all of the calls about the need for social media companies to censor misinformation, whether it be about the Ukraine war or it be about COVID or the 2020 election with Stop the Steal, almost always coming from the liberal left, advocating for these forms of censorship. But I guess the question I want to ask you is, do you think that like you said that you I think you said that you only blame the court for making this kind of a partisan issue by labeling this conservative speech. So do you see this as like kind of revealing in that claim that you just made that freedom of speech knows no ideologies, where like you have this opportunity to kind of really maybe attack like the kind of the collaboration between government and corporations on censorship, but you label it conservative speech, even though you're championing freedom of speech. And things like COVID or Ukraine aren't necessarily. I mean, they become partisan, but they're not inherently partisan. But the court order seems to be making them partisan. So is that revealing in this claim? Does that vindicate this claim that you just made?
Well, I think it helps answer the question of who politicized, the court ruling, right? I think the ruling itself was written in an inherently political way. So that's why I do think that what I've seen over 30 plus years of doing free speech work is that lots of people, almost everyone, talks about how much they love freedom of speech. But almost everybody, especially when you get into power, also wants to censor speech they don't like. And the only difference across this political spectrum is what's the speech I don't like. But the urge to censor exists across the political spectrum. I find it really interesting that the perception among your cohort is that most of the censure is coming from the left, because I think there is currently like a ton of calls for censorship coming from what I think we associate with the right, in terms of a lot of the laws being passed against drag performances, censoring of removal of gay and lesbian books from schools and from libraries. So I think you really, I think, could pick anything and find censorship coming for what you associate to be the left or the right or the middle. Everybody has speech they don't like, and when people get into power, they tend to want to try and suppress that speech, even when they put themselves out as free speech enthusiasts. And so that's what I don't think it's correct to hold one political party or any individual out as as sort of the champion of free speech, unless they really are the champion of free speech, unless they're really sort of saying that they're going to really even accept the right to publish material that they personally really abhor. And we rarely ever see that among people in power. So anyway, that's my current observation. I don't think this is a moment in time that's like, wow, at this moment in time, this political ideology is really great on free speech, this one isn't. I don't think that's correct in any way at all. Everybody, you could look, and there's people, the only difference is that this political ideology doesn't like this speech, and this one doesn't like a different type of speech. And again, I think what research has shown, the most recent research shown in terms of social media, that the most sort of censored ideological speech was pro-Palestinian speech. And so again, where you want to put that on the political spectrum, I'm not sure. But again, it doesn't mean it's the only thing being censored, even if it's the thing that tends to be taken down the most.
All right, great. Thank you so much, David Greene, for joining us. Thanks for taking the time, and we look forward to talking to you again.
Great. Yeah. Thanks so much.